Good afternoon, everybody. And I think Joel's last point there is really pertinent to some of the issues that I'm going to talk to you about, where he mentioned if you don't make too much profit, then the banks are unwilling to lend to you. And that is very pertinent for the construction industry. We're having issues at the moment where companies are declaring losses against previous financial years, where that is in the beginning of COVID, and I think that's only going to get worse. And I'm going to touch on the implications of that shortly. So for today's talk, I'm going to split it into two parts. So I'm going to talk to you a little bit about what I'm seeing in the current construction market with contracts and the problems that clients and parties that we're dealing with are facing in the construction sector, particularly with Brexit and COVID. There's no avoiding both of those. And then the second part of my talk, I'm going to talk about several very relevant recent cases on the subject of adjudication and insolvency, which directly affect insolvency practitioners and will affect your thinking on how you look to recover sums for insolvent parties. So first of all, dealing with the current situation, I think there's no doubt about it that the loss of lorry drivers, the loss of skilled trades has had a massive problem on the construction industry. So last year when COVID hit, the industry paused for a couple of weeks to work out how to deliver work safely. Imagine having lots of trades on site in very close proximity, carrying on trying to finish jobs to tight programs under penalty of significant liquidated damages for delay, some of whom need to work on a critical path, which is following on directly from the previous trade to make sure that they are hitting the exact program and the exact requirements to finish on time to deliver the end project. So you've got a situation where the project is in jeopardy and the industry stopped, and the Construction Leadership Council stepped in and issued site operating procedures, best practice, best guidance for how to keep personnel safe on site in the context of health and safety obligations, the CDM regulations, duties under employers' liability legislation, duties to maintain safe working environments for construction sites. The government also announced that the construction sector was a critical sector and must keep operating. So, the resourceful construction sector did come back and work out a way to deliver projects in as safe as manner as possible. But there were two obvious problems there. They needed extra time, and they needed to collaborate with clients, with end users, with banks to deal with the problems that had been faced and the delays that they'd suffered. And secondly, in some cases, they needed to ask for more money. And it's critical in terms of the funding and the cash flow and the intended end use about where that money was coming from, particularly flowing down in the supply chain. So we had a problem there with money and with time, and the Cabinet Office issued guidance to the industry saying you've got to collaborate, you've got to work together, you've got to figure out a way to get these projects finished in a collaborative way. Don't sue everybody immediately. Don't fall into the bad old trap of litigation and disputes. Try and work together. And by and large, 2020 was a collaborative time as everyone dealt with the effects of the pandemic. But we now are seeing the knock-on effect, the stored up problems of those issues from last year. So we have lost a number of skilled trades back into Europe as they've returned. We've lost a number of lorry drivers, which are critical to timely delivery of materials. And prices, supply and demand price effects are such that contractors are telling me in tender processes that they are only willing to hold their prices for 5 days, 5 to 10 days at most. Now, bearing in mind, Brexit, pre-COVID, supply and demand the other way around, it was very common for tenders to go out, prices to come in, and then expectations that contractors would hold their price for weeks and months while the funding lines were sorted out, while the agreements for lease, the pre-sales, the planning, everything was sorted out with the contractor sitting there holding their price. Now, contractors, if they hold their price at all in a bid, will only hold them for a very short period of time as prices, material prices across the industry shoot up rapidly. We've also got problems with HS2, which is sucking in resource. Whether you agree with it or disagree with it, it is improving the skills and knowledge in the infrastructure of this country, but it is sucking in all the skilled, experienced people and all the metal, electrical equipment, all the steel is being sucked into HS2. We're still dealing with projects at the moment where cladding, for example, is on a 6-month waiting list and people cannot commit to the programs they need. That is spooking buyers because they're thinking about their investments and their yields. That's spooking banks who want absolute guaranteed returns on fixed prices. So we're now in a very tricky position where the pressure is being exerted back down onto the building contractors and back down onto the supply chain. And they are quite rightly and quite understandably saying, well, we may be locked into bad contracts from last year that we are suffering with, but we've learnt our lessons, and the smart contractors and suppliers that have realised what's going on are now pushing back. So in a lot of cases now, the lump sum fixed price design and risk dump contract is not attractive to contractors, is not attractive for several reasons. There's no profit, there's too much risk, the programme is unachievable, the design information provided by the client is insufficient or unverified, and they are expected to check all that and deal with all the risks that come out of it. Now, when you factor in the supply chain problems as well, the price rises, the problems in the ports, getting materials in through the ports, it's no surprise that design and build contractors are not happy to bid for any job that comes across their desk. There are disruptors in the market who will take those jobs, but the well-established contractors are now pushing back and saying, well, we'll hold our price for 5 days, but where steel goes after that, we don't know, and we will come back to you. That has had an effect on a very recent job of mine, a health centre, where the contractor signed up to a lump sum fixed price last year and has been squeezed so much by his supply chain and slowed down that has now gone bust. And unfortunately, what that does is send the banks, send the buyers, send the occupiers, the private developer looking for ways to increase their security next time. So it's a vicious circle of people pushing back down onto the supply chain to ask for even more personal guarantees, even more bonds, even worse terms, payment terms. And that is flowing through into other areas. So another example that I've had recently, a contractor contacted me. They are struggling to get a performance bond. The bond market has tightened up, as has the general insurance market, and they are struggling to get a bond 4 months after they started work. They still haven't delivered the required performance bond. That is a problem because they signed the contract before the bond market tightened up on the basis of their previous financial test. And the contract they signed said that until you deliver that bond, you are not getting paid. And all sums that you would have been paid will convert into retentions released either when we get the bond or at the end of the job. And the contractor quite openly said to me, well, if the client enforces this, then I am going to go bust. And the bond surety wanted to scrutinise their accounts to such a degree that they were struggling to get any bond other than, from less financially stable offshore jurisdictions that the client wasn't particularly happy about. So you've got lump sum fixed price problems, you've got bond market insurance issues, And you've got the third problem, which is suppliers understandably wanting to see where their money is coming from. So I had another job recently where we've got cladding going onto a building. It's a tower block, which is being converted for Grenfell type problems to make sure it's fully safe and fire compliant. And the cladding manufacturer off-site elsewhere wanted a large lump sum up front to lock in that order to make sure that he would get paid and to guarantee that this was a genuine order. That is because demand is so high that they could pick and choose where they would place those orders and which customers they would work for. They want the security of private developers going bust on them and contractors going bust on them. The problem that then had was knocked back up through to the owner of the building and the banks who don't want to release advance payments. So we're in a long discussion at the moment about advance payment bonds, about other forms of security, about cross third-party guarantees, lots of inventive other ways to cover the need to access a lot of cash up front to deal with direct, immediate supply chain problems. So the first part of my talk there's practical issues that the construction industry is facing at the moment as a result of ongoing economic problems. The second part of my talk, I'm going to move on to a series of cases dealing with the crossover between adjudication and insolvency. Very relevant for insolvency practitioners where you are seeking to obtain recovery of sums that were owed. So it's worth just explaining what adjudication is, because these cases relate to adjudication. In 1973, the House of Lords, Lord Denning said, cash flow is the lifeblood of the construction industry. So after various reviews and government analysis, in 1996, legislation came in creating this concept of adjudication. Adjudication is intended to keep money flowing through the construction industry. It is intended to be one dispute, one answer. It is intended to be quick, 28 days, 42 days, compared to a High Court claim of 2 years. And it is intended to be temporarily binding. And that is the nub of the issue that the House of Lords, the Court of Appeal, the Supreme Court have been wrestling with for a long time in the context of the insolvency rules and the need to take the final account and work out the single final payment and who owes what to whom as a result of the insolvency rules and application. So going back to the first case, Supreme Court, Brescoe and Lonsdale, insolvent company wanted to chase their money and they wanted to adjudicate. And the risk if an insolvent company adjudicates is if you are on the wrong end of a temporarily binding award, then you have to pay money over to the insolvent company's representatives and then go to court or arbitration to try and overturn that adjudicator's award and get your money back. And the self-evident obvious risk there is that money isn't available. The High Court and the Court of Appeal both considered adjudication in those circumstances futile. And it's worth just remembering this name, Lord Justice Coulson, who comes up very shortly in the Court of Appeal, upheld an injunction to stop that adjudication because he was very firmly of the view that actually adjudicating to try and get money by an insolvent company that couldn't protect where that money was going was futile and the money wouldn't be available anyway. However, it went to the Supreme Court and Lord Briggs got hold of it and he overturned the Court of Appeal, he overturned the High Court, he released the injunction and he said insolvent companies can adjudicate. And the Supreme Court said actually there is a difference between the principles of adjudication and the reason it can be used and enforcing that adjudication to get hold of the cash. But in principle, the Supreme Court in Bresco have allowed insolvent companies to adjudicate. Now, in practical terms for the audience today and insolvency practitioners, what does that mean? So it could be useful. An adjudication could be useful if you need a declaration, if you need a simple decision, if you've got a very simple dispute, if there's a technical decision that you need guidance on. Adjudication as a matter of law can be used at any time. So while you're in the middle of wider court disputes, you could use adjudication as a tool to help you persuade the other party to do something. You can choose the adjudicator. It doesn't have to be a lawyer. It can be a quantity surveyor, can be a technical expert, can be some sort of engineer appropriate for the dispute. So you could still use adjudication to get an award in your favour as leverage to move on to persuade somebody to release money. But the Supreme Court in that case said, yes, you can adjudicate, but enforcement, going to court to make that order enforceable as a court order, doesn't need to be considered really by the Supreme Court in that case. They mentioned that enforcement will be unlikely, but it was judicial commentary around that. So we skip on to a second case, Meadowside and Hill Street Management. So having listened to what the Supreme Court said and allowing insolvent companies to adjudicate, the QC, sitting as a Deputy High Court judge in that case, took arguments around the risk of money disappearing into an insolvency process and not being recoverable, and what security could be put around that. So Meadowside, and the judge in that, acknowledges that actually if the security package is suitable, and if there is security to get hold of that money again, if the adjudicator's award is overturned and the payer wants his money back, if the security is adequate, then enforcement might be possible as well. So you're on to stage two, where you've got the ability to adjudicate and you can enforce subject to putting down security. And the judge in Meadowside looked at the type of security that should be put down. So he considered after the event insurance, he considered indemnities, he considered ring fencing, and various other ways that the liquidator would assure the court that if the adjudicator's award was reversed, the money was there, was safe, and could be paid back in total rather than a dividend distribution, pence in the pound. And the Deputy High Court judge in that case considered that process. So we've now got a position where potentially adjudication is useful to liquidators and insolvency practitioners. But then we get into the insolvency rules and the crossover between the insolvency rules and another House of Lords decision in Stein and Blake. And the judges in all of these are fixed by precedent and the seniority of courts before them and courts after them. And the third case that I'm going to mention to you today, John Doyle and Erith, is in the Court of Appeal, and it's with Lord Justice Coulson again. And you'll remember Lord Justice Coulson was the judge who had his decision in Bresco overturned. So he is now sitting there thinking, this issue has come back to me, and in Bresco, in the Court of Appeal, his view that the Supreme Court said was wrong has to be reconsidered. So Lord Justice Coulson, sitting in the Court of Appeal, now starts to think about the nature of adjudication and the interaction with the insolvency rules and the need to take an account in insolvency where everything is set off, the compulsory insolvency process of set off that I'm sure you're all very familiar with, where you are combining various debts, various legal causes of action, combine to create one central decision, one central account showing you the overall set-off result of who owes what to whom. Now, if you'll remember where I started, adjudication is one dispute, one award. It is temporarily binding. So in John Doyle and Erith, the Court of Appeal are saying, actually, although the case was handled really badly, they did comment on the interaction between insolvency and adjudication. So if you want to read John Doyle and Erith, you will see that it's a case study on how not to run a claim by the insolvency practitioners and the lawyers in that case. For example, the liquidators and the lawyers sent in an ATE insurance policy that was a blank template with no commitment by the insurers to ring fence that security. Remember, we're talking about security of the sum involved. They forgot to put it in the pleadings that they had any security at all when they went and asked the court to enforce it. They offered to pay money into court, which completely, in the judge's view, contradicts the whole principle of adjudication, which is to keep cash moving. So they went to court and said, don't worry, your lordship, we will pay money into escrow or into court, and you can hold it while all the adjudication is settled and all the insolvency set-off works. And Lord Justice Coulson there said, well, no, the whole purpose, going right back to where I started in the 1970s, cash flow is the lifeblood of the industry. We have to keep the money moving. So paying this money into court is the worst of all worlds and really a last chance saloon. If you can't ring fence, you can't offer any other assurances. So what Lord Justice Coulson said to all the insolvency practitioners and all the representatives of companies in this situation is, please give the court a very simple, unequivocal undertaking that you, the liquidator, the insolvency practitioner, will ring fence that money. If you are using third-party funds to run the litigation, you can't give an unequivocal undertaking because you've signed an agreement to pay those funds to the litigation funder. So some of you may be familiar with a couple of well-known companies in the market that are effectively putting money in to run these claims. And Lord Justice Coulson was saying, be very careful. You need to be able to give that unequivocal undertaking that the money is safe. So on the facts of John Doyle and Erith, the liquidators failed on all counts. The appeal was denied. The initial refusal to enforce was upheld because the security hadn't been pleaded, hadn't been explained, wasn't clear, and really didn't persuade the court that the liquidators were, in control of that security aspect and could guarantee the funds were there. But just drawing this to a conclusion, Lord Justice Coulson then went on to tackle enforcement. So he said insolvency set-off is paramount. Insolvency set-off is automatic. It applies to construction adjudication. And the problem is that an adjudicator cannot look at the entire situation of a company, all of its claims, all of its cross-claims that an insolvency practitioner would do in that insolvency set-off process. So Lord Justice Coulson, although his injunction was, his decision to uphold the injunction was overturned, he was able to bring it back to his original principle that he set out in Bresco in the Court of Appeal, which was that in his view, adjudication is going to be very difficult to have any benefit because you can't enforce it, because you immediately in an insolvency situation hit the insolvency rules and the limitations of adjudication and the problems of one issue, one dispute that cannot be resolved in the context of insolvency set-off. So Lord Justice Coulson said, actually, we're back to the same position where you've got adjudication, but you are going to be very unlikely to be able to enforce it, particularly in circumstances where the other side can start to throw counterclaims and cross-claims and set off and legitimately say, well, the adjudicator hasn't taken account of all of this, and you need to put it through the principles of insolvency set off under the insolvency rules. So just to draw this to a conclusion, and I'm conscious that there's a lot of information there about the case law. I'm very happy to explain it in more detail if anyone would like to pick this up separately. But the conclusion that I would come to today for the audience today, for insolvency practitioners, adjudication is not completely dead. There is still a place for it. There is a place for it, in my view, in terms of getting a declaration, of making decisions, of having persuasive evidence, but not perhaps getting hold of the cash that you might previously have been able to do. Thank you all for listening, and very happy, all three of us, very happy to take questions.
So there's one question that I wanted to ask, and I think this is probably a question for Joel and or Matthew. And this relates to a lot of scaremongering that happened during the summer about the lack of manpower for picking crops, fruits. And I don't recall that actually came to pass. So was that because somehow or other employees were allowed to come into the country, or how did that materialise? Perhaps, I don't know, Joel, do you want to go first?
Yeah, it materialised. It materialised in two ways. One, the farmers actually just didn't pick as much produce. That was partly helped by the weather not bringing things like soft fruit on quite as fast. So there were some gains to be had through the ripening process being slightly slower, which meant they could work with fewer employees. But many of them actually, their employees are paid piece rates. So as much as they can pick, they get paid, and they were quite happy to work longer hours in some cases and just pick more because they got paid more. But there was a big drive at the beginning of COVID to get British people out onto the fields. It failed miserably. You know, as a career choice, working in the fields is not one which your average Brit really wants to do, even though actually it does take quite a lot of skill to do it efficiently and effectively, and to know what you're doing, and you can earn good money doing it. It's hard work. You know, it is not comfortable picking strawberries in a polytunnel in the middle of the summer. It's better than it used to be, but I think, you know, in reality, businesses got by rather than anything else.
Matthew, do you have anything to add?
Yes. I mean, I think Joel's right. There were a number of mitigating factors which meant that what could have been a crisis probably fell short of being that, but still didn't leave us in an ideal situation. And some of it comes down to skill level, doesn't it? So, you know, as he's just explained, there is actually quite a bit of skill in picking that fruit properly, and in a way that actually means that it's still saleable and usable within the very short time frames that you've got, particularly with soft fruit. But as far as the UK government policy is concerned, this is not skilled work. So you will not get a skilled worker visa or anything like that to do this work. You're relying instead on the limited temporary schemes. And of course, the reason that those are not deemed adequate is because they are just that. And what we don't have anymore is the free movement from the EEA. And that, of course, supplied most of the workers who were doing that type of work before. And government have been really clear on where they're coming in policy. They basically said quite harshly, and I'd be interested again for Joel just to come back on this, that several sectors of the economy, and you know, fruit production, I'm afraid, is one of them, has been drunk for too long on cheap labour. And in order to get back to what Boris tells us is going to be, you know, a high skill, high wage economy, we need to break that by paying people more and therefore attracting local labour to do it. And, you know, Joel, as you said, that actually has failed miserably, in effect, picking up some of the things that I said earlier. So yeah, I would add all of that, and just pass that back, because I think actually, Elizabeth, it wasn't just scaremongering. I mean, there was genuine fear, and we perhaps got off relatively lightly this year. Next year isn't necessarily going to be even as not bad as this year was.
Sorry, school pickup time. My heart sinks sometimes when I hear the government talk. We have this. They say that, particularly agriculture, and a lot of we've been drunk on cheap labour. It's actually, for the most part, it's been driven by farm gate prices. If the farmers are not getting the prices, they have that price dictated to them, they have to make a profit out of it, which means they then have to cut their cloth accordingly. And that has meant that they have been, with the access to labour from the, say, the EU accession countries, where the economies were such that actually coming over here, it was a high-paid job for them over here. And they work hard. It's worked really well, because what it did was deliver UK produced food into supermarkets, particularly soft fruits, top fruits, etc.